Welcome, everybody. As Elizabeth said, my name is Patty Andreen. I am a lawyer, and I have been teaching bar review for 25 years. What you guys face that I never had to face is a super duper extra important MBE. And that's why we're doing this. And I congratulate you all on recognizing the importance of the MBE questions. Most law school classes teach the law through essays and case law, but we're really pushing that you work hard with the MBEs because it's half your score now on the bar exam. So I'm going to walk you through some types of questions, show you some strategies for focusing in on the right answer, try to teach you how to avoid the distractors because that's half the battle. Sometimes one or two of them look pretty good, and then you have to pick which one is there to distract you from the right answer. And that's what the bar examiners actually call them, is distractors. They have something appealing to them that is meant to hook you. And when they write the exam, the bar examiners expect to have slightly over half of you get the question right, and the rest of those who don't get the question right are expected to divide their wrong answers about equally among the three distractors. So every distractor has something that's kind of designed to get you interested in it and steer you away from the correct answer. The best thing you can do to avoid distractors is consciously analyze the facts as you're going through. You're all used to analyzing an essay. You've been doing it for a year or more. When you look at your MBE question, it's like a mini essay. So when you're reading through the facts, you want to look at the parties, the cause of action, the elements, and the defenses, just like you would on an essay. And focus on that more than you focus on the picks. The picks come later. So the first thing you want to do is focus on what is the fight about. And your best help in deciding that is the interrogatory. So you probably already know this, but I want you to practice it every single time you do either an essay or a multiple choice question, and that is to begin with the interrogatory. Now, when you look at the interrogatory, it may tell you what type of question you're dealing with, and I'm putting them roughly into four categories. There's two of a kind, which is a multiple choice question that has two answers that match. For example, plaintiff wins, and two that match defendant wins and give you a different rationale. Or in evidence, there would be two that say the evidence is admissible and two that say it's not. So you're looking at pairs in two of a kind. And when you get a question like that, it usually asks you for the outcome of the lawsuit or for the admissibility of a piece of evidence. Then you're most likely going to have two of a kind. And the best thing to do with two of a kind is first decide whether the evidence comes in or whether the plaintiff wins, or decide which way you want to go, and then try and get the best rationale. That type of question is not the most common, but it is very common, particularly on subjects like crimes, torts, and evidence. Now, tonight we're dealing more specifically with con law and contracts. And the most common type of question you'll see for those is probably going to be the best of the lot. With the best of the lot, you're going to get four choices that are possible attractive answers, and you have to pick the one that is the least flawed. How do you decide that? I'm going to show you that with specific questions, but I'll also give you some general rules. With the best of the lot, typically it's the one that fits the facts the best. You'll get a couple of legal theories that look pretty good in the best of the lot, but it's the one that fits the facts best. And if you have a couple of theories that look good and a couple of them seem to fit the facts, those are the hardest ones to decide because you have to have some sort of priority for guessing. Typically, I'm going to give you a couple of rules that will help you make that tough final choice. When you're asked to decide a case, the best of the lot is typically the one that will decide the case earlier in the analysis. Like in contracts, if you have two good fact patterns and two good legal doctrines, say something that deals with mutual assent is probably better than the defense of impossibility or frustration. Why? Because mutual assent will cut off the issue earlier in your checklist analysis. You got to have an offer and acceptance and consideration in your mutual assent before you even get to defenses like frustration or impossibility. And they will tease you with the defenses. But unless your defense is ironclad and really fits the facts, typically a better answer is going to be the one that resolves it earlier in the analysis. In con law, an answer that's an ironclad reason not to hear the case, like standing or justiciability, that's going to decide the case earlier than all the way getting down to the balancing test under the First Amendment. So with best of the lot, pick the ones that apply on the law and apply on the facts, and then if you have a contest and you can't decide which, typically the better one decides the case earlier in the analysis, and you don't even have to get to that final balancing or that final decision under standard of review. Another good guessing rules for con law, and please remember this one because it's commonly used in con law. If you're trying to decide the best of the constitutional clauses that would be applied in a particular case, and you're looking from the plaintiff's standpoint, what's the best the plaintiff can get? An argument that uses strict scrutiny. Because plaintiffs like strict scrutiny if they're trying to strike down a constitutional provision. Strict scrutiny helps plaintiffs. Now you have to decide if the question is asking you for plaintiff's best argument or defendant's best argument. If it's defendant's best argument, defendants want an argument that applies rational basis or one of the lesser standards of review. So these are some of the guessing rules. Now, what's the best of the bad lot? Those are tough questions. The best of the bad lot is when you look at the four choices and none of them look any good. None of them seem to be the way a court would decide the question. What you do there is look for one that if the court found such and such additional facts, they might go with it. So, for example, you look at the question and you think that plaintiff is going to win the case, but they want defendant to win. Sometimes what they'll do is they'll say defendant wins unless, and then they'll add some additional facts. The best of the bad lot, you may not like any of the choices, but they will supply additional facts in the choice itself that help that to prevail over the others. So we've got best of the lot and best of the bad lot. They're the most common types of questions. And then finally, there's anybody's guess. Anybody's guess are the ones where you really don't know what you're doing. And please remember that there are questions on there that are designed to test your ability to guess. You may not know some of the clauses they give you. Some of them are going to be off the wall. Until recently, nobody knew what the emoluments clause was. And there are some clauses like that in the Constitution that really nobody knows much about. Once in a while, you get a question like that. And on those, it's pure process of elimination. But we do have strategies for two of a kind, for best of the lot, and best of the bad lot. And those are by far and away the majority of questions you'll see. Now, one thing I'd like to say before we actually turn to the practice questions is the importance of taking your time with these MBE questions. You wouldn't race through an essay. You know that you've got 60 minutes for an essay. With MBE in con law and contracts, you could get some long fact patterns. They have quite a long fact pattern. So think of it like a mini essay and give it its due. Don't race through the facts. Spend the 1.8 minutes that you will have on the bar exam And don't rush to finish them, because even though you're all busy people, I know that. A lot of you have jobs, families, and lots of other things to do. If you really want to get the most out of your MBE practice, try to take the time to do a careful analysis of the fact pattern, just like you would on an essay. And don't just jump and guess the one that appeals to you, because it is possible that you'll score 30%, 40%, and then you'll just be depressed. Try to get your scores to come up into the range of above 50, 60, maybe even 70%. And the way to do that is take your time, analyze the facts carefully, and use the guessing rules to throw out the distractors and improve your accuracy. What we found is that students who do this bring their scores up consistently. And remember now, you've got to do this to pass the bar, because it's 50% of the bar. So congratulations on being here. Let's practice a couple of questions to illustrate some of these points that I'm trying to help you with. We'll go to the first contracts question. It's called question 2, but that's where we'll start. And are we going to start with the facts? No, we're going to jump down. Jump over that first paragraph and look at the interrogatory. Now, what are you looking for when you look at the interrogatory? Parties, theory, result. There it is. It's a beautiful interrogatory. It gets you very focused if you start there. Who's the plaintiff? The woman. Who's the defendant? The owner of the lumberyard. What's the theory? Breach of contract. And what's the question about? Will she prevail? So it's a two of a kind. And your answer to a will she prevail, you'll have 2 yeses and 2 nos. So once you decide if she wins, you've got half the battle, and then you come down with the rationale. So as you would in an essay, you might want to take a note on your question. WV lumberyard contracts. Now, if you're in your contracts class doing this, you don't have to write contracts, because you know that your professor's testing you on contracts. But when you get to the actual MBE and they're all mixed up, put your plaintiff, your defendant, your theory, and the focus of the question. Okay, so let's go to the facts and see what they do to distract you. A woman hired a builder to build a house. Okay, there's our first distractor. We have a contract in the first 10 words, but who's the contract with? Builder. And who's she suing? Oh, she's not suing the builder, is she? She's suing the lumberyard. So that throws a monkey wrench into the works right off the bat. A woman hired a builder to build a house according to plans drawn up by an architect. If you hadn't read the interrogatory, you might be thinking, what's the builder's liability? You might be thinking, what's the architect's liability? But you're not going there, because she's suing the lumberyard. The agreed price was $250,000, and with construction to be completed within 4 months. Looks like a solid contract. We've got all the requisite elements. 2 weeks after the contract was formed, the builder entered into a valid written agreement with the owner of the lumberyard. Aha, there's our second contract. But look, it's not between the woman and the lumberyard. It's between the builder and the lumberyard. If you have finished with your contracts class and you've gotten all the way to the end of the law, you probably know that this is a third-party problem, because the contract is not between plaintiff and defendant. It's between a third party and plaintiff. Okay, the builder entered into a valid written agreement with the owner of the lumberyard to supply the necessary lumber. 1 week later, most of the lumberyard's lumber supply was destroyed by a fire. There's our next big distractor. Oh, anytime they throw a fire or an explosion at you, that's exciting, right? And you start thinking, okay, impossibility or something like that. Don't get too excited, because the fire is not where the fight is. The lumberyard refused to supply lumber to the builder, who was unable to find another source, and told the woman he would not be able to complete her house on time. Now, if she were suing the builder might claim impossibility because of the fire, and nobody else can source it. But that's not where the action is. You have been distracted if you didn't read that interrogatory, but let's see what we can do with this now that we know what the game is. The game is to distract you with other facts But here we're going to stick right to the theory they gave us, woman v. lumberyard. Okay, answer A, let's take a look. That makes the woman prevail because the woman is an equitable assignee of the builder's claim against the owner of the lumberyard for breach of contract. I didn't see any assignment in there. I'm not too thrilled with that answer. Of course, we'd like the woman to prevail because, you know, she wants to get her house built, but that's not a good theory because it doesn't fit the facts. How about B? Yes, because the builder's contract with the owner of the lumberyard was not discharged by the fire. Well, that again is a distractor because it's not a contract with the builder, and the fire has nothing to do with her theory against the lumberyard. How about C? No, because privity of contract does not exist between the woman and the owner of the lumberyard. Well, that looks pretty good there because it is a third-party situation and she's not in privity with the lumberyard. And so maybe that's it, but take a look at D. D is better than C. And here's your first guessing rule. They kind of say the same thing, but D is more specific. No, because the woman is only an incidental beneficiary of the contract between the builder and the owner of the lumberyard. C and D both make the woman a loser in this case, and sort of on the same theory because of the third party issue, but D is a much more specific statement of why she loses. The specific answer here is going to prevail over the general answer. And the whole thing becomes rather easy if you do your analysis carefully and realize that we have two contracts here and that she's not suing the party that she's in privity with, but she's asserting rights as a beneficiary. Now, why is she only an incidental? Why is D correct? Why isn't she a third-party Benny who can enforce? Because it doesn't say anywhere that the lumberyard knew about her or intended to benefit her at the time of the original contract. Since she's not an intended Benny, she's an incidental Benny with no rights of enforcement. It's a good question to illustrate the two of a kind, and it's a good question to illustrate the rule that a specific answer that's similar to a more general one but sort of says the same thing. Usually pick the more specific as long as it's a correct statement of law. Okay, let's look at the next contracts question, which in your screenshot is number 11. And I'm going to leave this one to you. Please read it. It's short. And remember to start with the interrogatory. Don't start with line 1 on Wednesday morning. Go down to the line right before your 4 choices. And then read that question and make a guess and try to apply our guessing rules. This one is a best of the lot. It's not a two of a kind. It's the best of the lot type. See what you can do with that for just a moment, and I will be quiet, give you a chance to figure it out. Throw out the ones first that don't fit. I'm going to say that D is the easiest choice to throw out, an unconscionable contract. Because what do we see here that's unconscionable? These people are bargaining. in good faith. They're equal bargaining power. There's nothing about it that puts one party at a disadvantage. So D is out. What do we have? We have a contract for the sale of services, or we have a unilateral or bilateral. It's got to be A, B, or C. Now take a look at choice A. What's the matter with A? Just on its face. A contract for the sale of services covered by the UCC. Hopefully, when you saw that, you went, there's something wrong with that. The UCC doesn't cover sales of services. What does it cover? Sales of goods. Now, is this a contract for a sale of goods? Here's the trick again. In the first paragraph, the man says that he's going to sell his speakers. So it looks like it might be a UCC contract because they're talking about $15 for the speakers. But then the woman pipes up and says, don't do that. I repair stereo speakers. So hopefully you focused on that word repair. With any contracts question, whether it's an essay or an MBE, your preliminary analysis has got to be whether you're under the UCC or common law. This is common law because it's a contract of services. So D is an easy toss out. A is a pretty good toss out if you focused on the fact that services are not covered by the UCC. And then you get down to the difference between a unilateral contract and a bilateral contract. Look at the language. In paragraph 3, she says, if you promise to pay me $20, I promise to repair. So that's a promise for a promise. If you promise, I promise. Classic bilateral contract language. If it say, if you promise to pay me, I will repair them, and then goes about and repairs them, that's a little different story. But this is a promise for a promise. It's a bilateral contract. Remember under the UCC that an offer can be accepted either by a promise or an act. But we've already decided when we tossed out A that this is not the UCC. So under classic common law, it's a bilateral contract. This is a pretty neat little question. It doesn't have too many distractors, but it shows you how in the best of the lot, you can toss out those that don't apply on the facts, like unconscionable contract, those that aren't correct statements of law, like choice A, and then you're down to B and C. And if you've done your homework, you know the difference between a unilateral and a bilateral. And this is one that you should easily get right if you follow the approach, knock out the ones that don't apply, and then use your guessing rules to get the correct answer. Now, I know some of you are here because you're taking a con law exam, and I'd like to go over a couple of con law questions. If you're first year, these might be a little bit beyond what you've studied so far, but you can still learn strategy from them. The con law question number 3 is a source of power question. Please look at the interrogatory. In all likelihood, Congress's power to enact the legislation will derive from. Now, in con law, remember you have a source of power for the government, and then you have limits on power. And what you want to do when you're doing your factual analysis is zero in on which type of question you're dealing with. Source of power questions are very different from limits on power. With a source of power, it's typically a very broad answer because Congress, remember, only has a few sources of power. They're not very specific. And typically it's taxing and spending, or it's commerce that they base their power on. With a state, the source of power is usually the police power, but with Congress, it's typically taxing and spending or commerce. Once in a while, they have a question involving DC, where the Congress actually has something like a police power in Washington, DC to regulate government property. But with source of power questions, very broad. With limits on power, tends to be more specific, because there's many little specific things in the Constitution that limit Congress's power. The next question we're going to do deals with limits on power, but for this one, we're looking for a broad answer. Okay, let's see what they did. Congress enacted a statute wherein the government would purchase and operate all of the nation's airlines. Okay, whether you think that's good policy or not, they've got this statute, and what you need to decide is the source of power. They don't ask you to decide if it's valid. This is not a two of a kind. They don't say it's valid because, it's valid because, it's invalid because. So you don't judge it. You just tell them if it's upheld, it will be under which power. Let's look for distractors first. A is a distractor, the power to tax and provide for the general welfare. That's a misnomer. What is the clause? The power to tax and spend for the general welfare. This is a very common distractor. Sometimes they just call it the general welfare clause. But remember, with Congress, there is no general welfare clause. There is no ability to provide for the general welfare. That would be something akin to the police power. And who has the police power? The state, not Congress. So A is a misnomer. It's a common distractor. How about D? Let's go down and look at that one. That's another distractor here. The power to make laws regarding territory and other property belonging to the U.S. That is a valid power, but this is not property belonging to the U.S. Airlines are private property. So it would apply. Sometimes you'll see that clause used when Congress adopts a statute to protect buildings in D.C. that are federal property. Not going to apply here. It's a distractor. So now let's look at B and C. We're down to two choices. We've got a 50-50 chance, and I think a better than 50-50 chance here, because the power to raise and support an army and declare war, there's no facts to justify that. I mean, maybe if there was a war and they needed to nationalize some airplanes, you know, you could have a fact setting, but you don't. So let's go to commerce. Commerce is, of course, the most broad power that Congress has to regulate interstate commerce, and this will be our correct answer, C. We got there by recognizing this is a source of power question. It is likely to be a very broad answer, and this one fits the facts, so C is correct. Let's take a look at 15 now. Another con law question, and I'll tell you right off the bat, this one is a two of a kind, and it's a limit on power. Let's take a look at the interrogatory. The court will most likely. Whenever you see that kind of thing that's asking you to decide the case, it's typically a two of a kind. They'll either grant relief or deny relief, and they'll give you different reasons. Now, what can happen to you here is you can get turned around with granting relief and forget who it is that is seeking relief. So in this kind of a question where they're asking you whether the court will grant or deny relief, it's very important that you notice who is the plaintiff. So when you're diagramming and reading your facts, make sure you get that straight. It starts out in the fact pattern talking about a teachers union, and I'll read along, please read along with me, because we got to keep our parties straight on this one. A teachers union, which is a non-government entity, seeks to picket the local city school board for its decision to require higher certification for instructors who wish to teach in the gifted and talented classes in elementary school. Okay, so we have a teachers union, and what's their right they're trying to establish? Well, they're going to picket, so that's First Amendment. After a few days of picketing, the school board seeks a temporary injunction. Bingo. Now, who's our plaintiff? The school board. So make sure that you remember that the question is talking about, does the school board get relief? We're not going to try and give relief to the teachers union because the school board is filing the action. They want an injunction. They seek a temporary injunction in the state court to restrain further picketing of the school board. The school board insists that the teachers union has violated Section 101 of the city's picketing ordinance. And here's what Section 101 reads. Section 101, no picketing shall be permitted. Now, take a close look, because remember, with anything in the First Amendment, you've got to look at where it's happening, what the regulation is, and how broad is it. Because remember, First Amendment has got to be very narrowly tailored. It has a high scrutiny. No picketing shall be permitted where inside of or any sidewalk or street immediately adjacent or continuous, I think that meant to be contiguous, to public elementary and secondary schools without express permission of the mayor. Okay, so where is it to be disallowed? Sidewalks, streets, anything adjacent or contiguous to public elementary and secondary schools. That makes me a little nervous right off the bat, because sidewalks and streets, you know, that's where picketing usually happens. Applications for such permission shall be filed at least 3 days before such picketing is intended to begin and shall state the purpose, place, and time of the proposed picketing. So we have a permit process, which is typical. And you're going to look at the permit process, see if it's valid, but also remember the basic regulation has to be narrowly tailored. And what are they prohibiting here? Sidewalks, streets, and areas adjacent to schools. Who's seeking relief? The school board is seeking to enjoin the picketing. Okay, will the court grant relief? A, because the teachers' union failed to follow the procedure outlined in the ordinance. Well, they supplied those facts. You don't really know that, whether they failed to follow the procedure or not. This is a situation where they've given you additional facts in the pick. And typically when they do that, you have to assume for purposes of that pick, at least, that those facts are true. You might look up and not see them in the fact pattern, but assume for purposes of A that it is what they say, that they didn't follow the procedure. Let's hold on and see if that's going to be our best choice. B, grant relief because the ordinance is constitutional. So that would mean that the school board could stop the picketing because Section 101 is valid. All right, both of those make the school board the winner. Now let's look at C and D, where the teachers union wins. In C, they would deny relief because the picketing ordinance was unconstitutional on its face. And D, they would deny relief because the ordinance does not provide procedural due process. Well, I'm going to go with C, because here, with an ordinance that prohibits First Amendment activity, it's got to be narrowly tailored, and this one is overbroad because it applies to sidewalks, streets, etc. It's not going to fly as a reasonable time, place, and manner regulation. Procedural due process is thrown in there to kind of throw you off. You don't really know much about this process for getting a permit, and so they're kind of making that up to give you another choice. But in this case, what you remember is when you're looking at a limit on power, and particularly a First Amendment limit, it's strict scrutiny. It's hard to uphold these limits because they have to be narrowly tailored. And you've got to deal with standard of review. And remember that when you have a clause with a very strict standard of review, like you do with First Amendment, apply that, and that's going to affect your outcome. So I think C is going to be the best. You will have answers to these questions in the packet that Elizabeth sends you. I think we're already over time, just a little bit over. I wish I had more time to work with you on multiple choice. The best thing I can tell you is work with your friends in a group, and you can teach each other. Just as you work with friends when you're doing essay, and you kind of argue about how the essay should be answered, go ahead and argue with each other about the multiple choice questions. There's usually a pretty decent argument that you can get into without being disrespectful that would justify different choices. But see if you can learn to apply the guessing rules and make yourselves more accurate. I think that MBEs can be a solitary pursuit where you just sit down and race through them, but that's not your best way to learn. Your best way to learn is to consciously articulate the parties, the theory, and the result as you're going through the fact pattern. And if you work with someone else, you can kind of keep each other to that standard and get more out of your practice. Okay, good luck. Thank you for your attention.